obviously disappointed that this court did not judge in our favor. We obviously were confident that they would. That's why we launched the court challenge to begin with. We're going to obviously have to take the time to read it and read the judgment in full before we make a decision on what the next steps are going to be. So it's disappointing. The Supreme Court has, for decades, spoken unanimously about the importance of school boards' powers of management and control over issues of language and culture. And we feel that religion and religious liberty is a matter of culture that we should for which we have the right to manage and control within our schools. And obviously this judgment now has effect across Quebec. So as I said, we're going to have to take the time to study it properly, read it in full. We're obviously going to have to speak to our lawyers. Our lawyers have read the judgment in full, obviously, so they're going to have a pretty good idea relatively to advise us of what they think we should do. And then we're going to have a decision to make.
We're hoping to take this to the Supreme Court. We will have to, do a careful review to see what we can effectively take to the Supreme Court. I think there's a lot that we can. It's a long judgment. It's an important judgment, and that's why I think it'll be important for the highest court in the country to have their say. I've noted a bunch of paragraphs. I can't go over it in detail now, but I've definitely noted quite a few paragraphs that I think will give us enough material to go into appeal. I'm confident, without pronouncing myself on anything, I'm confident that this is a very appealable decision. It's a long, well-written decision, but I still think it's appealable.
The kind of violation of universal values, human dignity, respect, equality, freedom, justice, Bill 21 flies in the face of that. And we have fought it from the very beginning because we needed the courts to strike it down as much as we need the public to stand up, as many of them have done across Quebec, to say this is not who we are, this is not what we believe in, it is hurting ordinary people, and it is against the values that we hold dear. I think it's important for everybody that we take note of the devastating impact the notwithstanding clause has when it's used by a government to violate the rights of a marginalized group or marginalized communities in a particular location.
It's a great victory for Quebec, it's a great victory for all provinces, and it's especially a victory for Quebec's liberty, Quebec's autonomy, because of the part of the ruling on the notwithstanding clause. So basically what the Court of Appeal is saying is that Quebec can use the notwithstanding clause as it wish. It can use it preventively, it can use it on targeting many sections of both charters. There's just no problem with the use of the notwithstanding clause in Bill 21. We believe that the Supreme Court should not hear the case. I mean, the ruling of the Court of Appeal today is so clear, it's so obvious that the argument put forward by those who oppose Bill 21, they're so bad that, I mean, this must stop. It has been going on now for, 5 years? And it's been costing millions of dollars to taxpayers. This should be the end today. We won. They should stop their legal challenge. Now it's been enough.